Cheung was not even yet 2 years of age when she was taken across the road one day to visit with neighbours. At some point, without anyone realising, she got away from the rest of her family. Perhaps she wanted to go home. She headed for the roadway. Rosalie Derrick was driving along that road. The speed limit was 60 and she was driving at around 40 to 50 kilometres an hour. Suddenly, the little child darted out in front of her from between two parked cars. She managed to hit the brakes and veer across the road in an attempt to avoid a collision. She was unsuccessful and the car struck the child, causing serious injuries. A case in negligence alleged that had she been driving more slowly and carefully, she could have avoided the harm. The first instance judge found that the harm could have been avoided if Ms. Derrick had been driving more slowly through a suburban neighbourhood on a Saturday morning near Christmas. The Court of Appeal agreed. The High Court, however, found that there was no negligence. Their Honours in the High Court said, "Few occurrences in human affairs, in retrospect, can be said to have been in absolute terms inevitable. Different conduct on the part of those involved in them almost always would have produced a different result. But the possibility of a different result is not the issue and does not represent the proper test for negligence. That test remains whether the plaintiff has proved that the defendant, who owed a duty of care, has not acted in accordance with reasonable care. They found that once the matter was set in those terms, Ms. Derrick had acted in accordance with reasonable care by driving her vehicle at a modest speed and by making every effort to brake and avoid the collision. They said it was unlikely that an unattended infant of such tender years would dart in front of a relatively slow-moving vehicle on a busy road in such a way that a collision was, to all intents and purposes, unavoidable. From this case, we learn that negligence is not present simply because there was a way to avoid the harm. If a person meets their duty of care and harm still follows, the case may be tragic, but the harm may not amount to negligence at law.